So I think you might find this video interesting. As I said the other day, I settled with Bank of America so that they can proceed with the foreclosure on my house after me living there for like 5 years, no payments. I can't get into the details, the specifics of the settlement, but they paid me, it's a cash for keys deal. I get a settlement. I agree to walk away 90 days or less. I move out of the house, etc. I complied. I did everything by the book. They paid me, etc. I start getting letters, actually from them at first, saying I still owe the money. And then I rectified that. Guys, we settled. Why are you sending this? Oh, it's automated. We'll fix it. Okay, whatever. Then they sold the loan. They sold the loan to Carrington Mortgage Services with me as the one responsible for paying it. So I'm getting letters from Carrington. You owe us this amount. I sent them a letter in response, of course, certified mail. I dispute the validity of this debt. This is not my debt. I had a settlement agreement, cash for keys, with Bank of America, who should have never sold you that loan. I do not owe this. My wife does not owe this. Anyone with my last name does not own this. Here's the contact information from the lawyer that handled the settlement for Bank of America. Here's all their information, contact, etc. And at the end of that, do not contact me anymore about this debt. I did get contacted a couple more times, and now they hit my credit score, showing that I'm 2 months behind for something I don't even owe. So settlement demand is coming soon to Bank of America for gross violation of the settlement, for selling my mortgage to someone else and telling it's me that owes it when I don't anymore. I settled with you. It's yours now, Bank of America, not mine. Gross violation of the settlement terms. And number two, settlement offer request, to Carrington for trying to collect a debt that's not owed by somebody and then knocking my credit score. Ooh, I'm going to break one off in them. And as I was searching online, just curious, has this happened to anybody else? And I can't really find this specific thing where there was a cash for keys deal and then the bank sold the loan to somebody else and then they tried to collect it. I could not find that. But I did find a foreclosure website in Florida, another one, where they were posting, here's one of our clients, here's what happened to them, here's how we helped, they won, yada, yada, yada. And they even uploaded their responses or complaints to file a lawsuit online with the names and stuff redacted, at least of their client. But I got to read them in full. And I thought to myself, there's no way JP Morgan Chase, my favorite bank, went to this level on some poor, unsuspecting homeowner. There's no way they went to this level. And the truth of the matter is, yes, they did. They essentially hired a company. This is in Florida. And the company they hired are out of Tampa, Florida. Okay? So in Tampa, Florida, this particular company that JP Morgan hires, this lady went on vacation. She was still in her house and was just a little bit behind on her payments or whatever, or one payment. She had some kind of agreement with them. They agreed to it, whatever, like I'm catching up. And next thing she knows, she goes out for a couple weeks to see like a family member in a different state, comes back. Her locks have been changed. She finally gets back in the house. Stuff is missing, stolen. She called the police, filed a report. It's under a felony. This is a felony charge against whoever did this, which turns out to be the company JP Morgan hired. Okay? So I've got the case in front of me, and this was filed in January of 2015, Brevard County, Florida. I'm going to read you the allegations and essentially what they're saying you owe us. Comes now plaintiff, which is this person, by and through undersigned counsel, and sues the defendants, JP Morgan Chase, Inc., and a foreign profit corporation, hereinafter JP Morgan Chase, Mortgage Contracting Services, LLC Properties, LLC, a foreign limited liability company, hereas MCS, and John Doe, Inc., an unknown company, and alleges as follows. So here's what the person that owned the house is alleging happened. This is a lawsuit for damages greater than $15,000, which I'm not sure what the settlement or because I'm sure JP Morgan's going to settle. They're not going to let this go all the way through. Not a chance in hell. So I'm certain it's more than $15,000. I don't know what it is because it doesn't say. Stand by. Someone is ringing the doorbell. All right, back to where I was. So this lawsuit is for damages greater than $15,000. The plaintiff, whatever, is and at all times material hereto was a resident of Broward County. Defendant J.P. Morgan Chase. Yada yada yada. Let's go down to where it matters. Hold on. I'm gonna read you stuff that doesn't matter. The owner of the note and mortgage upon plaintiff's home retained defendant J.P. Morgan Chase to service the subject loan, or in the alternative, J.P. Morgan both owns and services the subject loan. You know why he put that? Because no one knows who owns the loan. Like I was saying earlier, who is note holder? That's what I'm talking about. So he's covered both. Either J.P. Morgan servicing it for some unknown note holder, or J.P. Morgan is servicing it for themselves, who is the note holder. So it says, the plaintiff was away from her home for several weeks in late November and early December 2014 to care for her blank, who blank and resides in blank, Florida. During her absence, the plaintiff arranged for lawn service. So she arranged for lawn service and her mail to be picked up. A person observing the property would know that it was not abandoned because A, the lawn was mowed, B, the mail was picked up, C, there was furniture in the residence, D, electrical service was maintained, and the air conditioner would regularly engage to cool and or heat the property. At all times, material hereto plaintiff blank maintained the subject property such that any reasonable person in the default property management business would know the subject property was not abandoned. At all times, material hereto plaintiff Jones had regular trash collection and paid for water and sewer services for subject property. The relationship between defendant J.P. Morgan Chase and defendant Mortgage Contracting Services is one of agent and principal, such that J.P. Morgan Chase, as the principal, is jointly and severally liable for any act or omission of its agent, Mortgage Contracting Services. Defendant John Doe, Inc. is a subcontractor that Mortgage Contracting Services, LLC may have hired. Both J.P. Morgan Chase and MCS are responsible for any conduct of John Doe, Inc. under principles of agency. On the afternoon of December 16, 2014, Plaintiff Jones returned to the subject property and found that her locks had been changed. Within the residence were notices posted by MCS, a copy of which is attached hereto as Exhibit 1. Many things were taken by MCS or MCS's employees or the agents of MCS and or employees of John Doe, Inc. Such items include, but are not limited to, those items listed in Exhibit 2, the police report filed by blank. Mortgage Contracting Services, LLC caused damage to the premises by breaking Jones' locks, disconnecting her water, disconnecting electrical power to appliances, and damaging the contents of the property. Count 1. Trespass against J.P. Morgan Chase and Mortgage Contracting Services, LLC, and John Doe, Inc. Plaintiff realleges the allegations contained in paragraphs 1 through 26 above and further states, on a day in December of 2014, one or more employees or contractors of Mortgage Contracting Services, LLC, entered the residence of Plaintiff Jones. The employee or contractor did not have plaintiff's permission to enter the subject property. At the time the employee or contractor of Mortgage Contracting Services entered the subject property, no court of law had entered a judgment in a foreclosure action with respect to the subject property. The employee or agent of Mortgage Contracting Services who entered the subject property had no legal right to do so. The employee or agent of Mortgage Contracting Services, LLC, who entered the subject property did so under instructions of Mortgage Contracting Services, LLC. J.P. Morgan Chase instructed Mortgage Contracting Services to secure the subject property. The entry upon the subject property by Mortgage Contracting Services was unnecessary for the preservation of the property. The entry into the property was a trespass upon the rights and property of the plaintiff. The plaintiff sustained damages as a result of the trespass. The subject property was damaged when the locks were changed, including the front or side door of the subject property. As a result of the trespass and theft of her property, plaintiff has felt powerless, violated, depressed, and anxious. Wherefore, plaintiff demands damages against Mortgage Contracting Services and J.P. Morgan Chase and John Doe, Inc. for trespass. Count 2. We're not done. But wait, there's more. I love this guy. Count 2. Negligence against those same criminals. Plaintiff realleges same things, etc. Above, J.P. Morgan Chase owed a duty of reasonable care to Jones in the servicing of her loan. Mortgage Contracting Services and John Doe, Inc. owed a duty to use reasonable care in conducting property inspections to those persons, including plaintiff, who owned the subject property. Mortgage Contracting Services and J.P. Morgan Chase, in the absence of property abandonment, had no right to enter or secure the subject property. Through the exercise of reasonable care, defendant Mortgage Contracting Services knew or should have known that the subject property was not abandoned by plaintiff in December of 2014. Mortgage Contracting Services failed to exercise reasonable care in its effort to determine whether or not the subject property was abandoned. Mortgage Contracting Services failed to exercise reasonable care in selecting vendors and screening employees, and as a result, persons who posed a substantial risk of damaging the premises or taking things from the premises were allowed access to the premises under the J.P. Morgan Chase or MCS work order. As a proximate result of Mortgage Contracting Services negligence, it entered a property that was not abandoned, i.e., the subject property. Plaintiff was sustained damages as a result of Mortgage Contracting Services entry into and modification to her property and theft of property that belonged to her or her children. J.P. Morgan Chase, as the principal, is responsible jointly and severally for the damages that resulted from Mortgage Contracting Services, its agents' negligence. Count 3. But wait, there's more. Intentional infliction of emotional duress. Plaintiff realleges what he said through 1 through 26 and further states, J.P. Morgan Chase utilized Mortgage Contracting Services to enter the subject property as a means to embarrass, humiliate, or harass plaintiff blank so as to punish her for not paying her mortgage, or in the alternative, to retaliate for his failure to pay her mortgage or to intimidate plaintiff. And wait, there's even more. Count 4. Theft against all defendants. The defendants, employees, or agents unlawfully removed from the premises items of value that belonged to the plaintiff and or her children. Among the things stolen were SD or secure digital cards that contained thousands of digital photographs that cannot be replaced. One of the items taken was an antique gold charm bracelet that previously belonged to the plaintiff's mother, now deceased, that cannot be replaced. Plaintiff has sustained financial losses from the loss of its property, together with great mental anguish from the violation of plaintiff's privacy and the loss of their digital memories. Plaintiff demands judgment from the defendants for such losses and mental anguish. But wait, there's more. Count 5, and this is what I'm talking about with my deal. Breach of contract against J.P. Morgan Chase only. It's what there says. Upon information and belief, J.P. Morgan Chase owns the mortgage on the subject property or has been assigned the mortgage. Under the mortgage, the lender may only secure the property if the property is abandoned and securing the property is necessary to preserve the property. The subject property was not abandoned. It was not necessary to secure the property for property preservation purposes. J.P. Morgan Chase violated the subject mortgage when it or its agents broke into the subject property and secured it in violation of the terms and conditions of the mortgage and without obtaining a judgment of foreclosure. Plaintiff was damaged by the breach of the mortgage. Plaintiff is entitled to her reasonable attorney's fees and her damages if she prevails in this breach of contract action. Wherefore, plaintiff Jones demands judgment for damages against defendants, mortgage contracting, etc., J.P. Morgan, together with interest, costs, and attorney's fees pursuant to the mortgage, and any and all further relief as this court deems just and proper, and further demands a trial by jury on all issues. See, this lawyer is an absolute expert. He knows exactly, precisely what he's doing. We also want a jury, okay? Demands a jury trial. Why? We don't want no stinking, rotten, corrupt judge telling us, well, that's too much money. You're not going to get that. It was an accident. I'll give you a couple thousand, get lost. No. Which, the court will have to decide any additional money. But they want the citizens to hear this case because they know the average citizen sitting down as a juror, hearing what just happened by this filthy, rotten bank and its criminal cartel under it, they're going to be pissed off and they're going to find this bank and this little affiliate, whatever, mortgage contracting services, guilty on all freaking counts. Pay this woman. And 5 counts. Count 1, paid. Count 2, paid. Count 3, paid. Count 4, paid. And count 5, paid. I won. Give me my money. That's what she's going to say. So this, they have, Exhibit 2, Exhibit 1, some of the stuff that was missing. I don't need to go over that. I'm not going to go over that. No point. But when this is posted on this blog, it's a whatever, the truth about loan modification.files.wordpress.com, whatever. But they're only posting stuff that this law firm won because they're proud of it. We won this, didn't say what they won. Of course, it's private, whatever, but they won. And I know the banks are rotten, but this is on a whole new level. This is on a whole new level. You broke into someone's house, changed the locks, stole their jewelry, stole things, cut their power off, cut the water off, and left a note on the door. I think there's going to be significant damages. Significant damages. Musical instruments were stolen, gold necklace, all kinds of stuff. And I'm going to be honest with you. You may not like what I'm about to say. You may not like this, but I'm going to say it because I would do it to these bastards if I had a chance. Which I don't because this didn't happen to me. But if I did, and they came in and changed my freaking locks and stole, some items from me, I had 20,000 ounces of silver. J.P. Morgan, the silver rigger. You want to talk about getting even? 20,000 ounces of silver is now missing. Prove me wrong. You changed the locks. You left the note. You were there, correct? Well, yes. Yeah. This person says that they had that. All you have to do is convince the jury. Do you think they stole that? Again, the jury's going to find you, your case for you 100% correct. Every count. And just to rub salt in that wound on J.P. Morgan, the biggest market rigger, I would lie through my teeth. Jason at 4, do you swear to tell the truth and nothing but the truth? Kind of, Your Honor. Can I say kind of? Or does it have to be pure yes? Because I really, have a conscience, but I can get back at J.P. Morgan. They screwed me when they dropped the price of silver and I got a margin call and I lost $3,500. I think just saying I have 20,000 ounces that was stolen, I'd feel kind of good about that. It's wrong. Super wrong. But it would make me feel really good. And I would love to do it. And I would freaking do it. What's the old saying? An eye for an eye, a tooth for a tooth. But that's just me. And that's a person who knows what these banks have done to people and would be licking my lips to get even. And if I came home and that was me, I would be doing backflips. Oh my God, do you know what these idiots just did? Do you know how much money they're going to have to pay me now? Oh, and by the way, JP Morgan, the silver market rigger, yeah, you can keep the prices low. It doesn't matter. I had 20,000 ounces in my house. These guys stole it. Whoever you sent over, they stole it. It's gone. It's gone. Sir, you had $20,000 worth? No. 20,000 ounces. In other words, an obscene amount of silver that I would never in my life be able to own. But just for the sake of saying, JP Morgan, I know what you're doing. Not just this foreclosure stuff, but the market rigging. I chose to say 20,000 ounces of silver for a reason. Wink, wink. See you in court, buddy. Jury trial. Piss off. That's what my little note would say to them, when the foreclosure at the very end, wherefore plaintiff demands such a P.S. JP Morgan specifically, piss off. You burned me in silver, and now I burn you back. Actually, I would never write that in that because that would be a telltale sign that I'm pissed off and trying to get even. Anyways, thought you'd like to hear that story because it kind of blew my mind when I heard it. I did not know they would go to those lengths. But they did. And they do. And they continue to do so. Take care.